Small-scale business organizations, Part 2. Business organizations are broadly classified into 4 types. These are business organizations in private sector, business organizations in public sector, joint sector business organizations, and public utilities. The small-scale business organizations of private sectors are divided into 3 subtypes. These include sole trading concerns, partnership firms, and Hindu undivided family firms. In this module, you will learn about partnership firms and Hindu undivided family business. A partnership firm is formed by joining 2 or more persons together. In India, the Partnership Firms Act was passed in 1932. According to Section 4 of this Act, a partnership firm is defined as the relation between the persons who have agreed to share the profits of a business carried on by all or any of them acting for all. For a partnership firm, the maximum number of partners is fixed to 10 if it is a banking business and 20 if it is a general business. Partners are broadly classified into 4 types, namely active or working partners, sleeping partners, nominal partners, and minor partners. Let us learn about each of these types. Active partners contribute a fixed amount of capital and share profits and losses in proportion to their capital investments. They take active part in day-to-day business activities. Sleeping partners contribute a fixed capital but do not take part in day-to-day transactions of the firm. They share the profits and losses in proportion to their capital contribution. Nominal partners neither contribute capital nor take active part in day-to-day transactions of the firm. They do not take any share in profit, but are liable for losses. Partners who are below 18 years of age are called as minor partners. A minor cannot become a partner, but by mutual agreement of partners, he or she can be admitted as a partner. The minor partners share the profits of the firm, but are not eligible for any losses. Apart from these 4 major types, secret partners, limited partners, and partners eligible only for profits also exist. The partnership deed is in written format, duly stamped and signed by all the partners of the firm. The partnership deed generally contains the name and address of the firm, names and addresses of the partners, nature of business, addresses of branches if any, and date of establishment of business. The partnership deed also contains each partner's capital contribution, the ratio of sharing profits and losses, duties of each partner, and division of work by each partner. The conditions to be followed while admitting a new partner, valuation of goodwill at the time of admission of partner, or at the time of closing the business, and the procedures to be followed whenever differences arise between the partners are also documented in the partnership deed. No legal formalities are needed for establishing a partnership firm. Even its registration is not compulsory. Partnership firms can be formed by more than 2 partners. This allows more capital investment. More partners ensure easy division of labor, which in turn increases managerial abilities and efficiency of the firm. The liabilities of partners is unlimited, which leads to increased credit worthiness. In partnership firms, profits and losses are shared by all the partners. Therefore, a single person need not have to bear the entire loss, as in sole trading concerns. The partnership firms can maintain their secrecy since they don't have to publish their accounts. Partnership firms are easy to dissolve. Any of the partners can apply for dissolution by giving 14 days notice. Partnerships have a number of demerits as well. Lack of unity among the partners leads to disputes and may hamper the business in long run. The capital contribution is limited since the number of partners is limited. Unlimited liabilities discourage many people to join as partners. Foolish decisions of some partners may lead to heavy setbacks in partnership firms. Death or insolvency of any partner leads to dissolution of the partnership firm. Partnership firms cannot gain public support due to lack of government control and secrecy. Transfer of shares to others is difficult in partnership firms. Secrecy of the business cannot be maintained since two or more than two partners are involved. According to the Indian Partnership Act of 1932, there is a provision for registration of partnership firms, but it is not compulsory. For registration of a partnership firm, a statement in prescribed format duly filled with correct details must be submitted to the registrar of firms, along with the prescribed fees. After compiling all the provisions, the registrar issues a certificate called as Certificate of Registration. There are many advantages of getting a partnership firm registered. Let us have a quick look at them. A registered firm can file a suit in the court against a third party, which is not possible for unregistered firms. Registered firms can also file a case against the partners against the loans that they owe to the firm. Any partner can file a case against the firm or the partners for dissolution of the firm and settlement of accounts. The Hindu undivided family business concerns are found only in India. They follow the Hindu law. The firms which consist of all the male members of the Hindu family, descendants from a common male ancestor, are called as Hindu undivided family business concerns. Only 3 successive generations of male members, namely sons, grandsons, and great-grandsons, acquire the birthright in ancestral property. The senior-most member of the family, called as Karta, manages the business. Liability of the Karta is unlimited, while liabilities of other members are limited to their share in the business. Let us now recap all the important points that we have covered in this module on partnership firms and Hindu undivided family business firms.